Hi, my name is Charles Green. I'm a certified family law specialist here in Los Angeles County. I handle divorce cases in the Los Angeles County area. We also take cases from Ventura County, on occasion Riverside County, um, the Inland Empire, anywhere within 100 miles. Okay, San Bernardino, but I prefer Los Angeles County. That's my home court. And I file most of my cases in downtown Los Angeles. So I'm going to be doing a series of videos to try to explain and share my knowledge of family law here in California. Today we're going to talk briefly about judgments. Judgments. All right. So, what is a family law judgment? Well, that's your exit strategy. How does it end? How does your divorce end? It ends with a judgment. And there are several types of judgments. But first, let's start with how does your divorce start? Your divorce starts by you filing a petition with the court. Then the petition is served on your spouse, and your spouse can choose to file a response to the petition where they would pay a filing fee to the court, or they could ignore the petition and do nothing. That's what we're talking about. What happens when you serve a petition on your spouse? And remember, you can't serve it. It has to be a process server or a unrelated third party. You serve you cause the petition to be served with a process server, is my best suggestion, on your spouse, and your spouse does nothing. That is called a default situation, default judgment situation. So how do we get from serving the petition to ending the marriage? Well, even though your spouse did nothing and they took that petition you served them and they tossed it in the corner and they never wanted to look at it again, okay, you still need to do certain steps. You need to do your financial disclosures. You must disclose what assets and debts you're aware of that exist on the date you're doing your disclosures. And you must disclose your income and expense declaration, which will have your paychecks on it. And this must be served on your spouse, as well as the original petition. Then you will file papers with the court saying that you did this. You're going to file what's called a declaration regarding service of declaration of disclosure with the court. All right. So now that we've got that out of the way, those are the necessary steps to taking a default. You're going to then submit after 30 days, after your spouse did nothing for 30 days, did not file a response with the court, did not pay a 435 filing fee, and you have done your disclosures, and you filed your declaration regarding service of declaration of disclosure with the court, you can now submit to the court a request for default. All right. Your default's going to be processed by the court, and your spouse is going to be in default. That means they can't file an answer anymore. All right. They are silent to the court. The court cannot hear them. Now, of course, there's always loopholes and ways around this, certain timelines, okay, motions that could be made to set aside defaults, but we're not getting into that right now. We're just going to do the straight default. Default has been taken. Well, now, how do I end the marriage? How do we end the marriage? You need to do a default judgment. A default judgment. This is a very important point I'm about to make. When you are doing a default judgment, it must match the information on the petition. It does not matter if you disclosed assets and debts on your disclosure documents, but you didn't put them on your petition. In a default situation, your default judgment cannot list assets and debts and relief requested that is not on your original petition. Okay? So take the time to do the petition correctly. You may want an attorney to help you, okay? Because if you leave out that house, you leave out that retirement account, you leave out a proper request for child or spousal support, okay, you're going to not get the relief. And the attorney's fees it would have cost you to have a professional attorney help you, okay, are far less in most circumstances than the asset or debt or relief that you have now foregone because you didn't do the papers correctly. You didn't know what relief to ask for on the petition, the original petition. All right, but anyway, moving forward, you're going to do your default judgment. It is going to match pretty much exactly the relief that you've requested on your petition. You submit your default judgment with your date of marriage, your date of separation, the types of things you're asking for, which could include spousal support, division of property, awarding the property to one person or the other if it's separate property, a child custody and visitation schedule. You have legal custody rights, you have physical custody rights, and you have a parenting plan. This all has to be laid out in detail in the original petition and in the default judgment. One exception to the rule that the party in default cannot be heard by the court is for child custody, child visitation schedule. Because it's children, there's this little exception to someone in default that they can always file what we now call an RFO for a custody and visitation schedule before the judgment is entered, the default judgment, or after to modify. And there's technicalities as to when they file it, at what point in time, and when it's heard, okay? Certain standards that need to be met to modify. But because the person is in default, this exception is carved out because children are very important. And even though your spouse is in default, the children should have a right to see their mom or dad or other partner, and a technicality like a default should not prevent that. So the court will hear an RFO for modification or to set up an initial schedule for a parenting plan, for custody rights, irregardless of a default in most situations. All right. But getting back to the default. So you're going to do your default real carefully. You're going to ask for child support the right way. You're going to divide the checking and savings accounts. Now, remember, simply stated, what your financial divorce is about is what existed on the date of separation. All right? What assets, what debts. There are different rules about when those assets and debts are valued and when they're divided, okay? But your starting point is what existed on our date of separation. What's the inventory of assets and debts? Those are the things that should be on your original petition if you anticipate a default judgment. If you do not anticipate a default judgment, you do not have to list all the assets and debts and items that are going to be divided in extensive detail on the petition. Okay. It's always good practice to do it, but there are circumstances where you know your spouse is going to appear because there's a lot involved in the case. Then that information does not have to always be listed in detail on the original petition. But if you anticipate a default judgment situation, you want to make sure everything's on that petition. Okay. That you want to divide or have the court address. So you submit your proposed default judgment to the court. There's several things the court can do. The court could issue the judgment. All right. Congratulations. Divorce over. You're divorced. Judgment issued. Or if the court has questions and there's some complicated issues on the petition and the proposed default judgment, like division of a house, retirement accounts, support requests, the court may call you in for what's called a default prove-up. Default prove-up. That's like a trial, okay, where you have to prove what you put in the petition. You have to prove that the house is not community property. So, hey, judge, give me the house. Give me the house. It's my separate property. It's in my name. Even though we bought it during the marriage, it's mine. Okay, it's in my name. Well, the court's going to look at that because the general rule is if something's purchased during the marriage, all right, generally it's community property. So you're going to have to explain to that judge why, even though your house was acquired during the marriage, why that should be awarded to you as separate property. And good luck with that, especially if you want to do it without an attorney. All right. But there are circumstances where a house acquired during the marriage could be your separate property, or a portion of the house could be your separate property, like the down payment. Let's say you got the down payment from your parents, or you inherited the down payment from your uncle, and you can trace that out. Well, you're gonna prove that at the default prove-up hearing, and the court will then award it to you as your separate property, either a portion of the house for an unequal division, all right, or the whole house or the whole condo, depending on what type of evidence you have. Evidence is everything. Okay. If you don't have the evidence, it didn't happen. Evidence is everything in a court case. It's not what you believe, what you discussed with your partner. It's what can you prove? What evidence do you have? All right. Other things, you might have a business. You might have personal property that you want awarded to you. There could be credit card debts. You might want to explain to a court why you want an unequal division. And if you have certain evidence, so be it. Let's say that your house was left out of the default judgment for whatever reason, because you didn't think your spouse would not participate. So you have a default situation. You might as well see it through, get divorced. And then what do you do for the assets or debts that weren't part of the default judgment or weren't handled in the default prove-up because you didn't list it in the petition? Well, that would be called omitted asset litigation. That can be done post-judgment. And that's a complicated subject, and that's something we'll talk about in another video. But the key point here is, remember, if you're in default, that means the court can't listen to you. So you find out there's a default prove-up trial, and you want to go, and you want to tell the judge why she shouldn't get the whole house or anything like that, or why you should get spousal support. The court can't listen to you. You're not allowed to talk if you're in default. The court may let you sit there and listen to what's happening, but you're not supposed to participate in the hearing because you're in default. There are ways of setting aside defaults within certain time parameters, time periods, but assuming you're in default at the time of the default prove-up trial, It's like you're not there. With the one exception, which, if properly filed, child custody, child support, parenting plan schedules, a defaulted party could, under certain circumstances, participate in those hearings for the benefit of the children, of course. All right. Well, I hope this was helpful, and I hope you're successful in getting your default judgment. It's a little more complicated to try and do it than to just listen to this video. But if you would like our office to help you with a default judgment or a much more sophisticated, difficult litigated judgment, or your divorce case, which is going to probably end, as most cases do, in a stipulated judgment, then give us a call here at the law office of Charles Green. We're at 3699 Wilshire Boulevard in the Mid-City area of Los Angeles. And we're right near the downtown courthouse where we file most of our cases. Give us a call, 213-387-4508. And if the timing is right, I'll give you a phone consultation and we'll discuss your situation to determine if representation from our office is going to work out well for both of us. Thank you very much and have a great day.